I've got a podcast called the Barbie Life 2.0 podcast. Don't we all? Do you think Mattel will sue me for trademark infringement?
Probably. Yeah, so let's talk a little bit about it. So, Mattel owns Barbie. Barbie is, an incredibly famous trademark, here in the United States and abroad for that matter. But when it comes to famous trademarks, trademark holders who own famous trademarks, what I would consider Barbie to be a famous trademark, kind of like Nike, right, or Apple Computers, Facebook, right? These are all famous brands, and they get a heightened level of protection at the USPTO, both from a registration perspective and an enforcement perspective. You have much larger rights as a famous company or as a famous brand owner than you do if you're just a regular schmo like me, right?
And this is sort of, I don't want, just a quick aside, this is like call it second level, right? This isn't the name of a company, this is the name of a product that is, you think is garnered enough to say, yeah, this is famous.
I would be very confident to say that they are a famous brand, in which case they get a larger swath of protection, even outside of their normal, I guess, channels of commerce, right? So you think of Barbie, you think of, typically you think of like obviously the dolls, right?
Right.
The movie, the TV shows, apparel, potentially, online store, e-commerce stuff, accessories. But, predominantly they're going to be like in that class 28, toy category at the USPTO. What this individual is asking, the Barbie Life is a podcast, right? That's going to be class 41, which is the same class that things like the Barbie movie are going to be in. Any Barbie shows or, cartoons are going to be in that same class. So I think, as an examiner at the USPTO, if I saw this application, I would think to myself, okay, twofold, right? I immediately think Barbie. Like, is this having to do with Barbie? If it's not having to do with Barbie, is it in a class that could conceivably be related to what Mattel is doing with Barbie, currently? And if I said yes, then, there's probably your office action right there. But, beyond that, even if there was no Barbie movie or Barbie cartoons potentially, right, you'd have to think to yourself as an examiner, is Barbie a famous trademark? And if so, do I need to kind of give it a larger swath of protection, outside of, the classes that it currently resides in? But I can almost guarantee Mattel's got Barbie registered in a dozen classes at the USPTO for just abstract, random stuff that you would never think would be branded Barbie, but it is. Yeah. So, and I can guarantee like Mattel, they're going to, crack down on this pretty hard. Yeah. Because they have attorneys, basically. I guarantee there's one or two attorneys that their full-time job is just to enforce Barbie, copyright and trademark infringements.
Some of these bigger brands, like you said, they have the resources to have attorneys, maybe even staff, watch for applications as they go through. Even if this one were allowed, if you will, they'll likely oppose it during the opposition
they'll
period.
Almost for sure oppose the trademark application if there was an application. Even if there's not an application, you're likely to get on their radar because as trademark attorneys, we typically subscribe to a bunch of watch services that look not just for like new applications at the USPTO, but common law or unregistered usages of the brand.
I don't take too much long on this one. One thought I had was...
It's a good question. I would, throw the flag on that one pretty quick.
Very good. Thinking a little, law school questions type stuff. If they're going for a critique, maybe they're going to critique the Barbie show on the podcast. It's perhaps arguable fair use on copyright terms. Is there any avenue to try to protect the podcast, given that it's a critique or review, if they disclaim the word Barbie? Or is it still going to be an issue?
It's still going to be an issue. Like they couldn't register and disclaim the word Barbie, Barbie Life 2.0 podcast, because it's pretty descriptive potentially. Podcast 2.0, like second version, it's pretty descriptive. So I don't think there's a whole lot here there's not a lot of meat on the bones to like try to get around the potential issue with the USPTO.
Awesome. So,